Ms. Merchant?
Your Honor, unfortunately, you're stuck with me for this portion. I'm gonna handle the motions to dismiss. There are, as you can probably imagine, Ms. Merchant, as the requester, has much more information about the factual details about
Yes, sir.
that she used. So if you have questions in this portion of the presentation, she'd be the one to answer those for you, and I'll defer to her. When it comes to the actual process, the overarching process, I can speak to that because I'm familiar with that, and I am the one who drafted our brief on the motions to dismiss.
Yes, sir.
So I'm very familiar with all of the law in connection with that. So where I think we need to start, Your Honor, is to kind of trim down what I think you need to do. First and foremost, I have heard you say many times about us naming the district attorney's office as a defendant, and I don't think we need to replow that ground. So I'm going to stand on the pleadings in our prior arguments with regard to the district attorney's office motion to dismiss. I think that's adequately laid out in both of the motions that were filed, as well as our responses. So I don't need to replow that ground. I think where the rubber hits the road here is with the DA herself and with Fulton County. And I think at the 20,000 foot level, Your Honor, I think you've hit the nail on the head. The process that Fulton County put in place here is what's led to confusion, not just by two members of the bar who've been practicing 20 years and can't figure it out. Imagine a citizen who didn't have the resources or the ability to interpret this stuff the way that we can. The process itself funnels every public inquiry through the portal. The portal is managed by the office of the county attorney. And when Ms. Merchant initially requested these records, it was not Dexter Bond or anybody from the DA's office who certified these records. It was the custodian for Fulton County, Shalonda Miller. She is the one who certified that the records were complete, not anyone from the DA's office, and certainly not Mr. Bond at that time. So part of the issue that we're dealing with here in the context of the 12B6 is, what are the factual issues laid out in the complaint, and have we sufficiently pled a cause of action regarding their compliance with the act, the facts underlying the compliance or non-compliance with the actual timeline, the 3-day timeline, and whether or not the efforts were not substantially justified that would get us to the fees portion. Your Honor brought up early on the issue of mootness, and that certainly is an issue for Your Honor to consider when it comes to the injunctive relief that we requested in the complaint. Has that injunctive relief become moot? And certainly to a certain extent with the production of these other documents, that is true. That is a true statement. And so the issues that we're litigating for injunctive purposes have been significantly narrowed down to the 4 things that Ms. Merchant, if she has an opportunity to discuss those, can walk through with these witnesses, because the critical mention documents are not the end of the story. They are the continuation of the story of us trying to get these documents, now pressing 9 months. So if we take a step back, Your Honor obviously has reviewed the Gonzalez case, and you're familiar with the pleadings in that case. As you probably saw from our briefing, I tracked a lot of that because the arguments that we didn't necessarily discuss this summer are now applicable because Ms. Willis is named in both capacities. And I think Your Honor's focus on this recent decision written by Judge LaGrua is important, because I think if we step back and we look at the motions to dismiss through the lens that the legislator intended us to look at the statute through, we see that the Supreme Court and the Court of Appeals, every time they address this statute, they come down on a broad view of the law, which means if you take a broad view of the law, you necessarily going to interpret the statute in the for instance, the word agency or whatever it may be to be more inclusive rather than less inclusive. And the cases are legion that says you interpret it in a broad, not a narrow approach for the purpose of making sure that when in doubt, public gets access to these records. So in that context, Your Honor, I think I'd like to deal with Ms. Willis's motion in her official capacity first. That's the one, and I think primarily because I think that has a threshold issue related to immunity, which if I were in Your Honor's shoes would be the hang up I'd have in the context of a 12B6, to be candid with you, because if she wins on that issue, which I don't think she's going to, and I don't think she should, theoretically, we don't get to stage 2. And I'll be candid with the court about that. If she's entitled to immunity, then she would be immune from suit. I don't think that's the case here. The law of immunity, as it's developed around DAs, particularly in the context of personal injury cases or civil rights cases related to damages actions against district attorneys, that's where the law has developed. And that there has never been a constitutional provision or case that says that the district attorney is immune from all actions forever and ever. Of course, if she could be sued for employment discrimination, for example, something like that, that deals with an administrative function or ministerial duty that she has to comply with the law. She's not above the law. In other words, she has to follow the law, and where she doesn't follow the law and it does not involve an issue of her discretion, she's not entitled to the type of immunity they've sought in their motion, and she shouldn't get it here.
I understand your position. One of the reasons that I kept trying to push to sort of drill down with Ms. Monroe is, do I have to reach that issue if the Fulton County District Attorney's Office is an agency / office / department / something that is capable of having an Open Records Act enforced against it, even if it is not a legal entity that could otherwise be sued?
I think that's correct, Your Honor. As long as we've got a defendant who's responsible for the records and they are properly named in the case, then I think Your Honor can avoid the immunity question as it relates to Ms. Willis. Certainly, the immunity issue is the stickier issue, one for which we hope we'd have guidance by now. But as I read the case law, Your Honor, the type of immunity they're requesting is an insulation from the suit itself, and the purpose behind the immunity, as I'm sure Your Honor is quite aware, is to not deter her from taking discretionary actions that she might otherwise be held accountable for after the fact. It allows her to do her job. So when we're looking at the immunity issue, it relates squarely to whether or not she's acting in her function as a judicial officer in the courtroom, because it's false arrest, it's malicious prosecution, those types of things where she's operating as a lawyer in the courtroom and performing her function as a constitutional officer who's contained within the judiciary. Just because she's contained within the judiciary in the Constitution does not mean she has judicial power. And Justice Peterson brought that up during the oral arguments. There's a fine line between being included in one portion of the Constitution and whether you have rights that are enforceable vis-a-vis immunity under the Georgia Constitution. The case law has not developed to insulate her from this type of case. And the whole basis that they've raised in their motion is that this is a private right that's trying to be enforced by a private party, our law firm, against another citizen. And that's not what we have here. The cases make clear that an action to enforce this statute so that they have to comply with open records requests is a public right. It is not a right vested in Ms. Merchant individually, me individually, our firm individually. It is a public right. So the statute, and if you interpret it the way the Supreme Court has recently interpreted it in a broad manner, I just don't have a feeling that the Supreme Court is going to interpret this statute to carve out Ms. Willis. And because it's a public right of the people as a whole. And that's why we did this.
Let me sidestep for a moment. So one of the arguments that Ms. Monroe made about who is the entity and who can be sued and who would be subject to this type of enforcement action. One of the arguments that she made is that Fulton County and Ms. Willis, in her individual capacity, that they were never subject to a request for records. And therefore, there's no basis for an enforcement action against them. Is it possible that the same proves true because the request was, for all intents and purposes, sent to the Fulton County District Attorney's Office, or is your position that it was either sent to the Fulton County District Attorney's Office or Madam DA Fani Willis in her official capacity, to the extent that she is the umbrella over her entire office?
I don't think it matters, Judge.
Okay.
The statute says it doesn't matter. If you look at 50-1871 B1B, that provides the mechanism by which a member of the public is to learn, for lack of a better phrase, as to who they're supposed to send the request to. And that requires the custodian of the record to designate an open records officer. And that is the person, if so designated, is the person to whom the public is supposed to seek the records. That is the portal. That is what they did. And that is what we did to get the records. Whether Dexter Bond is the custodian of the record, whether Willis is the custodian of the records in either capacity, or whether Fulton County is the custodian of the records, is a red herring, Your Honor. It has nothing to do
No,
with—
I understand that. I think what I'm struggling with is, as Justice LaGrua noted in the recent decision that I referenced a moment ago, and we all understand agencies, entities, et cetera, can only act through their employees. And so when I'm talking about who's the custodian, I don't mean, is it Mr. Bond or is it Ms. Miller in the county attorney's office? What I mean is, does the request have to be, in order for you to enforce an action against, either get penalties for failure to comply or injunctive relief forcing compliance, doesn't that assume that you have submitted a request to the correct agency / entity / whatever? And wouldn't that mean that if you did not submit a request directly to Ms. Willis, I'm speaking of her separately from her role as the DA or her office, the district attorney's office, then doesn't that mean that she at least wouldn't be subject to an enforcement action under this?
I'm sorry to interrupt, Your Honor. I completely disagree with that.
Okay.
I disagree with that for a couple of reasons. One, we actually did submit requests, which Ms. Merchant can talk about more freely, to separate custodians, one at Fulton County and one at the district attorney's office. So we did what we could to try to do that. But more importantly, Your Honor, we are required under the Act to follow the procedure that the agency sets forth for getting the records. We can't do anything else to get records other than to follow the mechanism they put in place. Because if we don't do that, we're barred from seeking an action. For instance, if we do it orally, if we call up the DA's office and we ask for something, we don't get the right to sue anybody. But they have told us how to do this, and if we don't do it that way, then we lose the right to enforce the action in the first place. So we have to follow the process they put in place, and that is the portal process. Now whether or not we later learn that some documents come from IT, some documents come from this area. Frankly, Your Honor, that is not our issue and wouldn't preclude us from seeking to enforce the action. It's up to the agency, in this case, the district attorney's office, Ms. Willis, whoever we had sued here. They all seem to fit within that hat of the person to whom we sent the request and who'd be responsible for complying. Now, let's put it this way, Judge. If we ask for different documents, let's say some of the documents, and we know for a fact now that some of the documents were only accessible in a format that we could open them and read them from the IT department, how in the world would we know that that was the person that had the right custody of that document by going through the portal? We wouldn't. So there's no way for an average member of the public to figure that out before they go through this process. So, as Ms. Merchant will explain later, there were many attempts to try to figure out to whom the request should be sent, what should be sent to them, and who is responsible for complying. If you put in place a system under the Open Records Act that's so confusing that two lawyers who've been practicing for 20 years can't figure it out, what in the world is the average member of the public supposed to do? They created the process and they created the custodian that's supposed to be responsible. They become responsible, whether it's the county, it's IT, it's Ms. Willis herself, it's someone in the district attorney's office like Dexter. I don't know who it might be, but we don't have the ability to identify those folks individually because they've set up the process that we have to follow. And
that's actually why I'm asking the question, because, for example, I'm looking at the list of individuals that you subpoenaed, and the most recent series of filings are an effort by the county to respond, file objections to those individuals. And other than Mr. Bond, who seems to be the designated, he seems to have some official designation as the Open Records Act person or the records custodian for the Fulton County District Attorney's Office. The rest of these individuals are individuals, excluding the ones, for example, like Ms. Geiger and Mr. Holmes, who are not with the DA's office. But the individuals that are with the DA's office, you might not have any reason to request specifically records that are in the possession of Kevin Armstrong except that you requested some records and I guess maybe saw his name on an email or something. That may be why he's identified here. My question is, you didn't sue Kevin Armstrong, right, for not complying with the Open Records Act. And so presumably the way this would have gone is somebody would have gotten this request and the call would have gone out saying, we need to locate documents that relate to this issue. And people who would have been expected to be in possession of such records were probably asked to look, or someone looked. But you knew that Fani Willis might potentially be in possession of such records, and you didn't ask her directly for those records individually. And so that all I'm asking is, didn't you have to have asked her individually for records she might have possession of, public records of which she might have possession, in order to enforce an action against her, number one? And number two, aren't you, if you can sue the DA's office, because those are their public records, or the Fulton County District Attorney's office, or Madam DA in her official capacity, do you have to sue and have relief against Fani Willis individually to get the relief that you seek?
Well, Judge, let me back up. I think I can answer your question, but I'll do my best. But I think what Your Honor is asking is there a requirement in the statute that we send a specific request to a specific person before a right to a lawsuit under the Act ripens? And I do not think that's the case. And we know that because the definition of agency is not specific to a person. It is to an agency or to an office. And so the person in charge of that office is the officer in charge of that office. And so to the extent there is an open records officer dedicated to that office, we would have to sue the officer in charge of that office and the office, which we have done. Imagine, Judge, imagine this. Imagine we got 40 or some pages in the initial production. There might have been, let's say, 10 witnesses, 15 witnesses identified by email in those documents. Your Honor's position would require us to send an open records request to every single one of those people. Putting aside the fact that there's no mechanism to do that in the way that they have it set up. If we were to do that, and if they did not comply, and they did not comply because they were not the one in charge of giving the documents over, or they did not comply because they gave documents to someone in the chain of command who said, I'm not giving those documents, we would be forced to sue everybody in the office.
I'm not suggesting that. What I'm suggesting is that you never, I don't think there's any doubt that whatever we call it, you used a Fulton County portal to request district attorney records that either belong to the district attorney's office or to Madam DA Willis as the district attorney. But you never actually requested records from Fani Willis, except to the extent that she might have been in possession, just like Mr. Armstrong or any of the other individual employees that work at the district attorney's office, except to the extent that she might have had documents that were responsive to the request. That's the only distinction. I'm not suggesting that you have to go sue each individual employee that you think might have possession. I'm just saying that you never formally requested records from Fani Willis individually. You either requested them or altogether requested them from Fulton County, from the DA's office, and from the DA as an entity. That's what I'm trying to get at.
I object to you getting records. I object to you getting records.
Right, and just think of, if we take that argument to its logical conclusion, Your Honor, that means that someone as a member of the public who does not know how the district attorney's office keeps their records, or by whom they entrust the records, or the method or mechanism by which they collect records or save records, that would require us to send potentially dozens, if not multiple dozens, of open records requests to get documents, not knowing how they're stored. So let's take IT, for example. We didn't know IT was the proper person to subpoena until recently. No one told us that. We had to dig for 9 months to figure out that we had to send a subpoena to IT. How would the average citizen, interpreting the Act broadly and in favorance of disclosure of records, how in the world would someone figure that out? They wouldn't. And what would happen, and which is what happened to us for a long time, is we were told, you have everything. There is nothing else to get. And Ms. Merchant will explain, and probably, if allowed, question some witnesses about documents that she has in her possession that we directly requested related to forfeiture, that they have told us they don't have. So I think on a global level, Your Honor, there's a balance that has to be struck in the statute between the public's right to access information they don't have control of and the open records officer's requirement to comply with the statute, knowing the records. And so I don't think the statute requires the public, the citizen, to make that distinction. I think it's up, and I think the law would make that burden placed on the person who's in charge of the records. In this case, Ms. Willis and her office, or to the extent only maintained by IT, Fulton County. And so I just don't think that the statute, the way it's written, the way it was designed to be interpreted, would require us to send a request directly to Ms. Willis in order to say she had not complied and would prevent us from an enforcement action under 73. I just don't think it would be interpreted that way. I don't think the Supreme Court would interpret it that way. And I think the policy behind the statute requires the agency, Ms. Willis, the district attorney's office, to identify an open records officer. And to the extent that there's any issue with the way the request is sent, they are to follow up and let us know, hey, that's vague, that's overbroad, or they have the right to assert objections within 3 days. So putting all that aside, Your Honor, I do think when it comes to whether or not she's subject to the act, I think Your Honor has hit on the point appropriately, but I also wanted to point out that they keep focusing on this limited definition of agency, but the act also in 50-1873A says it can be brought against persons or agencies. It's not limited to an office. It's not limited to a specific, entity. We can sue people, individuals. And I think that's important because Ms. Willis in her individual capacity, I have no idea, Your Honor, whether she was involved directly. I know historically she's very hands-on. And so I don't know if there's a policy in her office where open records requests that are sent to her office are funneled to her directly. We alleged in paragraph 22 that she should have known and probably did know about these requests and that she had an obligation to ensure that they were not destroyed.
So your office objected to us getting Delta records for flights that you may have taken with Mr. Wade.
And, well, no, look. I object to you getting records.
At the time, we didn't know about IT, had no idea that they could actually be accessed electronically. So there's an allegation in the complaint that she did have knowledge about these requests and that she was responsible for complying with them. So I don't think that she's allowed out on a 12B6 because.
And that's that. I don't mean to beat a dead horse, right? But the reason I keep coming back to it is because I agree with you that the intention of the act and its definitions and inclusions is intended to be so broad that it would reach out and grab, agencies and individuals. But I guess the reason I keep coming back to Ms. Willis individually is that if you had filed suit against Ms. Willis and you could not demonstrate to me that you had ever actually submitted an Open Records Act request to Ms. Willis, I understand your argument is, well, I functionally did because I submitted it through the portal and they're supposed to identify the right people. But if you never served a request on Ms. Willis for public records in her possession, then you obviously, I think, couldn't sue her for failing to comply with an Open Records Act request that was never made. And so the only reason I keep coming back to that is, for example, in that case of Milleron versus Antonikakis, the defendant in that case, the records request was also made to Georgia Tech, but they specifically separately served a request on Mr. Antonikakis. Again, I'm sure I'm butchering that poor man's name. But if they hadn't, there'd be no universe in which you could enforce against him the obligation to produce records. And that's the only point I'm trying to make regarding individual Ms. Willis. Is she obligated under the umbrella of if she's got open records, public documents in her possession to produce them in response to a request that's properly submitted to the custodian? Sure. That's the only reason I keep beating that dead horse about whether or not individually Ms. Willis is an appropriate party. And I wonder if the distinction that we've not yet discussed is perhaps because of the issue of that you run into frequently with people who have these official capacities where they may be subject to immunity, right? There's this issue of, do you sue them individually or do you sue them in their official capacity? Is that the distinction? Or do I not need, am I overthinking that part of it?
I don't think you're overthinking it, Your Honor. I think you're appropriately focused on the issue. I think the distinction, though, with this recent case and why they focused on the fact that there had been a request to Georgia Tech and to the contractor. I think the distinction here is if we sent a request to Miss Willis personally, it would have to go through the portal anyway. So everything funnels to the same place. That was not the case in this Georgia Tech case. There were two separate entities to which they could send the requests. There's only one here, and it has to go through the portal, and you have to choose. You have a drop-down menu. And the reason I keep bringing that up, Your Honor, is because the statute requires us to follow their process. They designate who you have to funnel the request through. And I don't think it's accidental, Your Honor, that all of these requests go through a portal. Years ago, when we sued Fulton County years ago, and I can remember at the time their open records officer saying to me, we need a process in place so I can keep track of documents that are going out of this place because I have no idea. They're not making copies. I don't know what's going on. And that's when they set up the portal. That portal was set up on purpose to eliminate documents going out of Fulton County's door without them knowing what was in there. So they created the process, and that envelops everything. That the commissioners at Fulton County itself, all these individual, like as you mentioned, the tax commissioner, the DA herself, everybody is now within the umbrella of this specific mechanism that we are forced to use under the statute. So my long answer to your question, Your Honor, is I think it won't matter if we send it to her directly because they'll force us back to the portal. And if we went back to the portal, we're left without a remedy to sue the person who may be in charge of the records under your theory. We would just have no recourse. And Your Honor is appropriately focused on the right question in terms of her individual capacity, but there's no way for us to send her, practically speaking, as a member of the public. We cannot send her a request. It has to go through the portal.
Out of curiosity, I mentioned I had looked at some of the briefing associated with the Gonzalez case that's pending in front of the Supreme Court. It was a little unclear to me. The case, the entitlement of the case is simply Deborah Gonzalez. But it is a little unclear to me in terms of the underlying facts, if the request was sent or if Ms. Gonzalez was sued as Deborah Gonzalez, or if she was sued as Madam DA Deborah Gonzalez.
So I believe, and I don't quote me, Your Honor, because I don't know the facts of that case perfectly. I know generally what was argued because I watched the oral argument. I believe that they sued her office, and they sued her in what capacity? I cannot candidly tell you that, and I don't want to misrepresent how she was named in that case. But I do believe they think she was personally involved, failing to respond. Beyond that, Your Honor, I don't have more to offer you. We certainly can. I've spoken with the lawyer who's argued that case, and I frankly just didn't ask him that question. I was more concerned about the immunity issues and how they address those.
And it's not dispositive of anything other than, call it the rule of judge's interest, other than the fact that I guess we'll eventually find out the answer to that question from the Supreme Court. So
that's right, Your Honor. He for what it's worth, he doesn't think that decision is going to come down until later this fall, perhaps October. So it's not coming anytime soon, at least in his estimation. I'm not sure why. I think perhaps with the delay in oral argument, it got moved to the next term of court, which would have allowed them more time to decide the case. I don't know, but that's my best guess.
Well, I have no idea what the outcome would be, but I would think that Justice LaGrue would be well suited to write an opinion since she's so well versed in the structure and function of the statute. But in any event, go ahead.
Yes, Your Honor. I would believe that would be appropriate, but you know how they make their own calls up there. I know some of the justices were much more involved in orals than others, so that's never a good indication as to who's going to write it. But I can tell you they were hot for both sides, so it's hard to predict where they're going to go on that. I think if we look at the recent decision and how the court and the Court of Appeals have interpreted this statute before, I think they're going to find that she's going to be subject to this act. And I think Your Honor pointed it out a little bit early in terms of how do we know that the General Assembly intended her to be subject to this act? I think we only have to look at the exception in A4 where there's a pending prosecution exception. Clearly, at the time that they created that exemption in the act, they contemplated that at some point somebody would be responsible as a DA for complying with requests for those records. And again, we're not asking for investigatory records. These are sort of these are public records that relate to financial issues, expenditures, time off, county, that kind of stuff that have nothing to do with her role as a prosecutor in the courtroom. And so I think, if you look at the pending prosecution exemption, clearly the General Assembly, when they enacted that, contemplated that district attorneys would be subject to the act. And historically, the courts have recognized that. There's a number of cases cited in our brief where the courts have actually ruled whether or not the DA had actually complied with the request. So in practice, the courts have been operating under the assumption that DAs were subject to the act. So this argument that
which would also seem to be implied by the fact that the district attorney's office has an Open Records Act custodian and routinely complies with Open Records Act requests. But
yes, I mean, and this is also cited in the footnote to our latest brief. I think we raised it in the first brief as well, but they have Dexter Bond's letter that goes out actually is entitled Open Records. It signs off Open Records. It gives specific information about fees that would be charged, all the process involved in that. And so they're operating, whether or not they want to be bound by it, they are operating with the idea, and they are representing to the public that they are subject to the Open Records Act. And I think that's important because, as Your Honor pointed out very early in questioning the opposing counsel, we've named 4 people and they are still telling you we don't have the right people. We've named everybody that we knew we could name in order to get to a broad enough level that somebody would be responsible, and now they're telling us that's not enough. So in terms of evaluating the statute's purpose, they are telling this court that as a member of the public, we are forced to go and find somebody else, not Fulton County, not the district attorney in her official capacity, not the district attorney in her individual capacity, and not the office. There's somebody else. How in the world, if you interpret the statute the way the General Assembly wanted us to, how in the world does that comply with the spirit of the law? It doesn't. And the motions, Your Honor, and not to hold Ms. Monroe's feet to the fire, but Your Honor asked this question, and we were right there with you. Okay, if it's not this person, then who are we supposed to name? And I think the way she phrased it, and not to hold her to this, but I think the way she phrased it is the way I've seen that, Your Honor, is they sue Ms. Willis in her official capacity. Well, the reason we ended up naming her in individual capacity is right after Your Honor's hearing on that, we got an email that basically asserted substantive objections under the statute to requests that were then months old. They had told us they were not going to give us documents now because they were asserting an exemption well beyond the 3 days where they need to assert it. So that told us.
Was that the work product and attorney client under sub 41 and 42? Is that what those were, or was it something else?
Gosh,
I don't want to misstate what it was,
Okay.
and I don't have it in front of me currently, but I do remember specifically thinking they've asserted substantive objections under specific exemptions in the act that they had not done before. And that came on the heels of that hearing. And I thought to myself, well, why are they doing that?
it's right here.
And so,
It's Judge, we filed it. It's Bates number merchant-0365. It is an open records response. It was very random. We got it July 10th, and we had gotten in that request.
Well, the reason I recall it is I think you mentioned it in your second amended complaint. And so that's the only reason I recalled that. But also Ms. Monroe and Mr. Bowman aren't double teaming. So let's stick with one at a time. Sorry, Ms. Merchant. Go ahead.
I don't want to misrepresent either. The reason we sued Ms. Willis in her individual capacity, if you may remember during the hearing, I said we hadn't done that because we didn't have any information that she had personally been involved in the open records requests. I made that representation to the court, and it was accurate. We didn't. And so that's why we didn't sue her in her individual capacity. It was only after that hearing when we got that email that we believed that she had been involved, and that email was a direct response to the hearing. And so, and I don't know if it came, I don't want to speculate as to whether it had anything to do specifically with the hearing or what the outcome of the hearing was. But all I know is the timing was awfully coincidental. And so our belief, and having been involved with Ms. Willis and other proceedings, our belief was that she was personally involved in making decisions about what was going in and not going, what was going out and not going out. And so because some of the requests, Your Honor, deal directly with how she was spending the county's money. And so when it comes to whether or not we've satisfied the requirements in the 12b-6, I think the complaint does that. I think the bigger issue, and one that I think the court can probably move around, is the immunity issue. But with regard to the actual 12b-6 issues beyond immunity, I think, Your Honor, if we're allowed to proceed in this hearing and talk to some of these witnesses, I think this is the picture Your Honor is going to see. You're going to see that Miss Merchant followed up almost on a 2 or 3 day week basis. She was routinely trying to get answers for why these things had not been produced. She was not unclear about it. But I think you're going to see the initial request was not responded to within 3 days. They sent a generic letter initially that said, hey, we got your request, thank you, which is under the act a non-response. Under the act, within 3 days, they have to tell us whether they have responsive documents and whether or not they're going to withhold any of them based on some exemption in the act. They did none of that. So the 3 day requirement ran without their compliance as an initial matter. So that has to do with whether or not we crossed the hurdle into whether they were substantially justified in not complying with the statute. I think the evidence that you're going to hear from these witnesses is, one, that they still have not given us documents after 9 months, despite repeated requests to do so, that they have intentionally stonewalled Ms. Merchant by not providing adequate electronic links for the documents, and by not doing the appropriate searches for the documents, which is an issue we raised with the court last week. They're all over the place, Your Honor. The evidence is going to be that sometimes they certify documents as complete by one witness, and then we'll get other documents from a different witness that should be included in the certification from the other witness. And it goes all over the place. I don't pretend to know the details. I've watched her work, so I know that there is a lot there, Your Honor. And in the context of a 12b-6, what I'm suggesting to the court is these are issues that can only be resolved through testimony. And in a normal course of events, because this is a civil action, we'd be in discovery. We'd send document requests and we would take depositions. And that has happened. Historically, when Open Records Act cases are filed, there is a discovery process. Just like there is under the Civil Practice Act, we'd be entitled to serve document requests and take depositions to clear all this up. We brought the witnesses today, Your Honor, and hopefully we'll have a chance to speak with them today and tomorrow so that Your Honor has an understanding of the facts about these requests so that they're not amorphous, that you understand very concretely what efforts were taken to get them and what efforts were made to stonewall us. Because I think that dovetails entirely with the whole purpose of the act and the enforcement action that's set forth in 73. This is the only recourse we have, Your Honor. That the way that they have set the process up, there's no way to negotiate to get the documents. They force you to file a lawsuit. They leave us with no choice. And so if they're going to do that, then there has to be accountability for it, and an accountability for not providing records when the public asks for them that are clearly public records and for which they made no objection in a timely manner. And now they want to continue to try to stonewall us. I don't want to say it's in an election year, but we're in an election year. And the delay that's happened in part due to me not naming the right people to begin with, we're right up against an election, and we're still seeing documents come in that Ms. Merchant asked for in January of this year. Some of which they claim they don't have, like a pamphlet involving a flyer about, they said they don't have records, Your Honor, for a very concrete example. They said they don't have records as to the number of lawyers they have employed in their office and when they were hired. We asked for information specifically about when lawyers were hired and the number of lawyers on staff. They have a whole pamphlet, has a photograph of the DA's office that they use public money to pay for, and they tell us with a straight face they don't have any information related to who they have on staff at any one point. We know that's not true because they have to pay them. There are payroll records. So it's just one concrete example, Your Honor, of how, and I think Ms. Merchant and I were talking about this, I think part of what's going on here is there's been no accountability for these people, that people give up. They quit because they've made the process so hard and so burdensome on the average citizen that they don't have the time or the resources to fight. And so the 4 motions to dismiss are the latest example of that, Your Honor. That they'll stop at nothing to make sure we can't get a clear understanding of what they have and don't have, and if something has been lost or destroyed, when that happened. I think if Your Honor's inclined to deny the motions, I think you will see through these witnesses the pattern of obfuscation that we know has occurred. For all the reasons that are put forth in our brief, we don't think she's subject to immunity, and we or the defendants collectively are subject to any kind of immunity, and we think they're all subject to the act, and we think they're all proper defendants because of the way they have set the system up. We have no choice but to sue everybody, and we didn't want to do that. That's not our hope and prayer every day when we wake up. We have over $1,000 in costs that our firm has expended on this case to get it filed, to serve witnesses, to get the lawsuit itself served, all sorts of case expenses for subpoenas. All of this stuff adds up, Your Honor, and the average citizen probably wouldn't do it. We're left to try to uncover what's going on here. And so, unless Your Honor has additional questions related to the legal piece on the 12b-6, I will add one thing, Your Honor. I think if Your Honor wants to convert this motion into a motion for summary judgment, I think you'd be entitled to do that and hear the evidence. I think under Rule under 91156, we as the plaintiff would be entitled to 30 days notice and be able to respond to it. But we waive that. And let's press on. Let's hear the evidence. Let's hear the testimony. And then Your Honor can make a ruling in the context of a more complete factual picture than trying to resolve this thing as part of a dispositive 12b-6. So
Okay.
for all those reasons, Your Honor, we'd ask that all 4 motions be denied.
Thank you. Ms. Monroe? If you would not mind, I am going to take about a 5-minute break and then come back right at 4 o'clock and then let you have an opportunity to reply or rebut. Okay?
Thank you, Your Honor. I was just going to mention that was actually Ms. Monroe was just forced to take a similar break. So
Sorry, understood. So we are going to be in recess for about the next 7 minutes. I'll be back at 4 o'clock. Thank you. Counsel, I apologize. I'm a little past when I said I would be. The plaintiffs had concluded their argument. And so, as I said, I would give you the opportunity to respond since it is your motion. You get the last word.
So just a few things that I wanted to respond to. Plaintiff has been saying this ongoingly that because of the mere use of the portal, that it basically attaches liability to everyone in Fulton County, even leading up to the Board of Commissioners, as a result to a violation of the Open Records Act. And that because this is the only means in which to submit an open records request, everyone's on the hook. That is completely erroneous. The portal is simply a mechanism. It's simply a means in which that was put in place to help the public access information regarding government. It was merely to increase the public's ability to get information.
That's the problem. Your lines are blue. Draw them with red ink.
The Open Records Act was never created to be adversarial. The sole means of the act was to help the public obtain more knowledge on how their government is being ran. Now, the way that plaintiff wants us to utilize the Open Records Act, he wants the public to use the Open Records Act as a vice. advice to attack, advice to harass, advice to, if you don't do this, then I'm going to sue you. That's not what the Open Records Act was designed for. This was not the only way in which to submit a open records request. There's multiple ways in submitting open records request pursuant to the statute. You can submit one by email. You can submit one over the phone. You can submit.
Well, not really. I mean, if you submit one over the phone, I think I understand that you don't have the same rights and remedies to enforce it, number one. And number two, if like Fulton County has done, or maybe the district attorney's office has done, or maybe different departments, if you designate a records custodian, then in order to take full advantage of the enforcement mechanism, if those records aren't produced, aren't you required to submit it in the way that they want it submitted?
You can submit it by fax. You can submit it by email. So there's multiple ways in which to submit an open records request. You do not have to use the portal.
I understand that, but doesn't that to some extent limit the enforcement rights that a person who submits a document not using the portal might have?
No, absolutely not. Absolutely not. If it's only a verbal request, that's where the limitation lies. But if it's in writing, there is no limit. All right, and as it pertains to sovereign immunity, unless it's explicitly waived, the immunity lies. We can't do away with the immunity for the broad application of the Open Records Act. I do believe that because this issue, as it pertains to the Open Records Act, is a novel one, and which is why it's pending before the Georgia Supreme Court, why there are so many questions here. But we cannot supplement what the law is for our thoughts and our opinions as to how it should be applied. And that's what plaintiff wants us to do here.
So I have a question. We were talking about the different ways that one may submit a request. Let's see, OCGA 50-18-71 sub B1A, I'm sorry, B1B2, there we go. It talks about an agency designating one or more open records officers to whom requests should be submitted. Has Madam D.A. Willis and or the Fulton County District Attorney's Office followed that procedure to designate one or more open records officers upon whom requests for inspection and copying may be delivered?
We've identified the custodians for both Fulton County and the District Attorney's Office.
I'm not sure that you're answering the question that I asked. I understand that in the process of this litigation, it has been identified that Mr. Bond is an open records person. He's the custodian of records and serves in some open records capacity for the District Attorney's Office / Madam D.A. Willis. And I also understand, I think, that Shalonda Miller with the Fulton County Attorney's Office operates in some capacity for the Fulton County requests. But my question was, the statute that I was referencing says an agency that designates one or more open records officers upon whom requests for inspection may be delivered shall make such designation in writing and then provide notice, and you have to file something with the legal organ of the county. And so my question is not, have you identified them in this lawsuit? It was, has either entity, the county or whatever entity, DA, et cetera, followed that procedure and designated an open records officer?
The county, I believe, yes. I don't know for sure. I have seen things in writing concerning the county, but for the District Attorney's Office, I am not sure.
Okay, thank you.
I believe plaintiff went into a lot of the substantive matters in addressing the motions as it pertains to the actual requests themselves, the list of hirings, a brochure with a picture of Madam and some of her employees. I mean, that I would like to reserve my response to those allegations if and when we proceed to an actual hearing on the merits.
Right. And I think that's fair, Ms. Monroe. In fact, one of the questions I was about to ask, to the extent that it sounds like we're sort of wrapping up, is towards the end of plaintiff's counsel's argument, there was a discussion about, what to do with the case should the court deny any or some or all of the motions to dismiss, such that something would proceed. And then we would need to get into the merits of the actual requests that were made and the extent to which these witnesses have information about the extent to which the Open Records Act requests were handled by the entities. And so one of the questions I have is, I think I understand that the reason these witnesses were produced today, or, subpoenaed for appearance today, in the event that I deny the motion to dismiss to any or all of the entities, is that the defendant's argument is none of these entities are the right entities. But the backup argument is the requests are moot because we've produced all the documents. And to the extent that that forms a basis for dismissal, then is it appropriate for the court to hear from witnesses who may or may not, or at least allow the parties to examine witnesses who may or may not advise that there are all documents have been produced or not? Or am I exceeding the authority that the court should exercise under 12B and converting it into a summary judgment motion if I hear from those witnesses? And so, to clarify what that was a really long-winded question, if I hear evidence, I don't wish to hear evidence about the substance of these documents or why they were requested, which isn't relevant, and all this sort of stuff. It's really about what efforts were taken to locate and identify, and what assurances are there that all the documents were produced, which is an argument to defeat the claim on the basis that the claim is moot. What are your thoughts on that procedurally, Ms. Monroe?
Thank you for asking, Your Honor. I think procedurally for this to actually to honor the rules of civil procedure, I think it would make the most sense to rule on the motions. Once we have a defendant to proceed, then we can if it's in the court's discretion, move to discovery. If not discovery, then straight to a hearing with the proper defendant of the court's choice.
Okay. I'm going to briefly ask counsel for the plaintiff if you want to respond. I mean, you mentioned this concern. I understand that I can, if you're willing to waive notice, can sort of hear that evidence now, but I mean, it really is. I'm just wondering if it's going to be too difficult to separate these things out in terms of the substance of the requests that were made, separate from the efforts made to locate, because the types of documents that might exist is a different discussion than what reasonable efforts did you undertake to locate documents that might be responsive to the request, which does go to the issue of mootness, which is part of the motions to dismiss.
Yeah, Your Honor. I mean, the strict tenets of 12B6 say you're confined to the four corners of the complaint.
Yep.
I have to concede that because that's the truth. So if Your Honor wants to hear any evidence that's not in the complaint or the second amended complaint or not attached to the complaint, you're going to have to either allow evidence on the motion, which would then presumably convert it into a Rule 56 motion, requiring notice to us, which we've obviously waived. We intended, based on Your Honor's instruction, to question these witnesses about the very things that you have talked about. So the presentation of the evidence is geared around the efforts they took or did not take, and what issues are still outstanding with regard to at least 4 requests. So that is the focus of the inquiry, and I do believe it is tied to the motion to dismiss issues. But I think if you go beyond the 4 corners, you're going to convert it into a different motion. On the other hand, you could simply deny some or all of the motions, which would then allow us to vet the issues in discovery. And to the extent the county or anybody else who was left in the case, any issues with the scope of discovery, it would proceed like a normal civil case.
Okay. And then thank you. And that directs me back to Ms. Monroe. If, let's assume for a moment that the court, that one of the defendants is going to remain in this case as a potentially appropriate defendant to seek to enforce Open Records Act remedies against. What is your suggestion for dealing with the mootness issue in terms of either allowing for some very brief discovery period or scheduling a substantive evidentiary hearing at a fairly close from now, but later in time date to discuss the substantive issues of the documents and the efforts undertaken to comply with the Open Records Act? What are your thoughts on that, Ms. Monroe?
The portion of my motion that does talk about, that speaks to mootness, wasn't inserted as part of the motions to dismiss, but as a second part to this proceedings, which goes to the merits, to say, in the event that the court finds that the defendants in this case should not be dismissed from this action, and this was only pertaining to, I believe, the district attorney's office. That was only found in the motion to dismiss for the district attorney's office, not in the other motions. That was just to basically be addressed in an evidentiary hearing. But the goal was for the court to rule on the motions as to who would be the defendant to be sued, or dismiss the complaint altogether. But assuming that the court were to find that there was a defendant liable under this action, and that was a defendant that was named in the caption, we would then proceed, once the ruling was made on my motions, to an evidentiary hearing if the whole action was not dismissed altogether. If that makes sense. I don't know if I'm being clear.
It does. No, I understand your position. But the next question then is, if the court were to, again, let's assume for a moment that some defendant is going to stay in this case.
Mm-hmm.
What is your preference or suggestion about what to do next? Would you, really the options are some expedited brief discovery period, and or a fairly expedited, soon to be scheduled in the near term, evidentiary hearing to address these issues, or both. Any or all of the things that y'all pick and that I decide on, or I'm telling you going to be expedited because that's how the statute is designed.
Right.
But my question to you is, what is your preference? And what, if it's a discovery period, what do you think is a reasonable time period for that?
So no, this is a very straightforward case, in my opinion. So I don't believe discovery, there would be any need for discovery.
Mm-hmm.
So it would be my preference to just move forward on an evidentiary hearing in the event there is a defendant that would be held liable under this action.
Your Honor,
Yes.
may I jump in quickly?
I was just about to call on you, so yes, please.
Okay, so I think one wrinkle here is, I think Your Honor has the ability today to rule on the motions. And if Your Honor does that, then
I intend to.
Yeah, then 2 things happen. The automatic stay that's set forth in 911-12F goes away.
Right.
So once the stay is lifted, then your honor would have the ability today and tomorrow to hear the evidence. The hearing, our concern, your honor, is that based on the history, that as soon as we attempt to conduct any discovery, whether it's 2 weeks of discovery, a month of discovery, there are going to be motions filed that prevent us from accessing information from witnesses. Whether it's going to be a motion for a protective order or some sort of motion under 9/11/37. I don't know what it might be, but it's going to delay the proceedings. So I would caution your honor, if the court is inclined to move with some speed here, and that
I am inclined to move with speed. I only inquired about discovery because I didn't know the extent to which either party was interested. It sounds like Ms. Monroe's response is that she thinks an evidentiary hearing is the better course, and it sounds like you do as well. So I think that addresses that issue.
Yeah, and I do want to just highlight, your honor, I think the issue of mootness has been introduced today through counsel. I don't think the issue of mootness is relevant for purposes of the 12B6 motion, because the complaint as it stands without evidence says that they have not complied with the law. They have not complied with the statute. That is accepted as true at this stage of the proceedings. So to the extent that she's arguing outside the pleadings that some or all of these claims are now moot, I get the practical piece of it. We have alleged that they are not moot in some form or fashion, and that a lot of these requests are still outstanding. So the issue itself, as pled in the complaint, is sufficient to defeat the motion on its face. So we would just, our preference, your honor, in terms of timelines would be for your honor to rule today, or as soon as practical, since we have the witnesses here, perhaps bring them back in short order to proceed, because I think the parties agree the issues are fairly narrow, but still contested.
Understood. Ms. Monroe, anything to add?
I have nothing to add, Your Honor, nothing else.
Okay, so as I have, I think, made pretty clear, I am somewhat frustrated by the idea that there are 4 defendants and none of them are somehow responsible for producing documents, despite the fact that some documents have been produced. And clearly there are people whose job it is to receive these requests and process these requests and attempt to secure discovery. Attempt to secure requests, the responsive information. So here's what I am left with. Again, I will say how much I would love it if the Supreme Court had given me the answer, because as it stands, I'm going to give you the answer I think is appropriate, and the Supreme Court may tell me I'm wrong in any moment. So, there's that to look forward to. Having said all of that, I think I've made very clear, I understand the effort at the distinction, but I struggle to see how Fani Willis individually is an appropriate defendant here, because she was not served. I understand that she received internally probably requests. She was not served with a formal request for records that she was in possession of, other than to the extent that the Fulton County DA was served with a request. And so I have real concerns about that. And I understand the import because of the concern about immunity that potentially attaches to MDA Fani Willis. But I think there's a distinction for a reason. And so I am going to grant the motion to dismiss Fani Willis in her individual capacity. Having said that, however, I am denying the motion to dismiss Fani Willis as the DA, and I'm denying the motion to dismiss the Fulton County District Attorney's Office, and here's why. Number one, as to DA Willis, the District Attorney, I agree, has some broad immunity that attaches. But I agree with the plaintiffs that the traditional understanding of immunity that attaches to a district attorney was not intended to limit or inhibit the public's right to access non-prosecutorial documents, non-investigative documents that are held by the district attorney. And I think that if the legislature had intended so, it would have exempted district attorneys generally, and it did not. And so for that reason, I'm going to deny the motion to dismiss as to District Attorney Willis. I am also going to deny the motion as to the Fulton County District Attorney's Office. And I do that with the most hesitance because clearly the Fulton County District Attorney's Office is not a legal entity that can be sued in any capacity. However, I don't think there's any way to read the Open Meetings Act provisions that are adopted by reference in the Open Records Act provisions without understanding that the Fulton County District Attorney's Office is an office, agency, department, et cetera, of Fulton County or of the state, and therefore would be subject to the Open Records Act requirements. As to Fulton County, I do have concerns, as Ms. Monroe pointed out, that any ruling that I make be understood as overly broad in the sense that any request submitted to any department of Fulton County using its portal somehow makes the entirety of Fulton County responsible. And that is definitely not going to be my ruling. However, to the extent that Fulton County hosts the portal and is clearly subject to the Open Records Act, particularly here where the agency and the officer are denying that they are subject to the act. The county clearly is, and the county is hosting the method to request and receive responses, to submit requests and receive responses and responsive documents. And so to the extent that the county is doing so in the absence of the records custodian, i.e. the district attorney in her official capacity, or the Fulton County District Attorney's Office, such as it is constituted for purposes of it being an agency or office, the Fulton County stays in the case as well. So that's going to be my ruling. I am, as I said, I'm granting the motion to dismiss as to Ms. Fani Willis. I'm denying the motion as to the other defendants. Mr. Merchant, can you please provide me with a proposed order that I can edit regarding my rulings in this case?
I sure can, Your Honor.
Ms. Monroe, can you please provide me a proposed order granting the motion to dismiss as to Ms. Willis? And again, I don't mean to be disrespectful. She's entitled to that title. I'm only doing that to distinguish her in her individual capacity. Sometimes no answer is an answer. And so some of the email traffic that I've received over the last few days is, wait, what about these witnesses? What are we doing? And the choice to have the witnesses available was intentional. And so that means I owe those witnesses an apology for holding them up today to the extent that they are here and have not been called upon to testify. And so as of today, they are released, but not indefinitely. It does not sound as if anyone needs or wishes to have any sort of discovery period. The Open Records Act is intended to be an expedited process because it's intended to allow the parties to obtain the documents that they are requesting. And so it is my intention to expedite an actual evidentiary hearing regarding the efforts that were undertaken, the nature and scope of documents that might exist, and what efforts were taken to locate such documents that would be responsive and in the possession of the Fulton County District Attorney's Office, DA Fani Willis, and Fulton County to the extent that no other entity is subject to the act. That's going to be my ruling. I believe in the interest of expediting, I was originally set for a trial week next week, and I believe it's been indicated to me that many of those parties' cases are going to resolve. I believe that concludes this matter. Anything else, Mr. Merchant?
Nothing from the plaintiff, Your Honor.
Ms. Monroe?
Nothing further, Your Honor.
Thank you so much. All of you have a good time, a good day. I will see you I'll see you on the 19th. I'll send out a notice and I will look for your proposed orders. Thank you all.
Thank you.
Merchants' interests are contrary to democracy, Your Honor, not to mine.
If you put in place a system under the Open Records Act that's so confusing that two lawyers who've been practicing for 20 years can't figure it out, what in the world is the average member of the public supposed to do?